Amazon is not an arbitrator. They said, hey, you have this item that is violating our patent. They actually went and shut down our listing.
What happens is if in a year the trademark office denies your trademark, you have no protection, you lose your brand registry.
Someone takes you down like a patent troll. Are they responsible for damages of your lost revenue, lost earnings, potentially lost rankings?
It's sort of a yes and no question answer. Traditionally, no. But what was interesting about our case is we got the court to actually say yes. But the number one reason it's done, I just want to say, is like most people do it because they expect the other side to walk away.
This is the Aaron Cordovez Show.
All right, everybody. So today I have the most legal savvy guest we have ever had, because this man has been for over a decade, almost 2 decades, an attorney, legal counsel, fully certified lawyer, qualified under the bar. And Paul Rafelson, he is also an advocate and helper for Amazon e-commerce sellers who get in trouble with Amazon and possibly others who get in trouble with the law. Or, hey, rightfully or wrongfully, things happen. Lawsuits happen. We are in America. We are known for being litigious. We are known for law, both bad and good. So whatever part you get caught in, you need somebody on your side. And so that's what Paul is here today to do, to tell you what your options are and what it is important, what's legal important, what's Amazon rules important. And so we're extremely happy to have you on the guest. Paul, welcome to the show.
Thank you so much. That was an awesome intro. Thank you. I'm so excited to be here.
I'll tell you that when people start normally on Amazon, right, or e-commerce or business in general, a lot of times they have no idea about anything legal, never even file a trademark. They could be in business for many years and have no idea at all about the law. Now, how common is it that you see people, like that? I mean, for me, I see it pretty common. But people that have zero knowledge and could be, having violations just by literally knowing nothing.
Yeah, I know. I mean, it's my saying is like, when I talk about my business and people ask me about my market, who are my clients, who are my competitors, my answer to the question, who are my competitors, is, so this will sort of tell you where I'm coming in from. It's not other lawyers. It's not like there's another lawyer out there who's killing it and I'm like, that's our competitor. There's a whole group of us. Like, there really aren't that many lawyers who serve in e-com. My biggest competitor is LegalZoom, I find, and Trademark. It's those websites that just sell the service of like, okay, you want an LLC? Here's an LLC. But no thought given to what it means. Are you actually achieving the protection that you're seeking? Similar with trademarks, people just, want to get a trademark on file. They don't really want to put any thought into will it get accepted, which is a big problem, especially if you're on Amazon. So you're right. Like a lot of times when people contact us, we're the first time they've ever worked with a lawyer, which is why we've actually structured our our fees. We try to be a little bit easier with startups and companies that are just getting started, because we sort of invest in our clients in that respect, and it's paid off. I'll be honest with you. Just given the number of exits we did, especially in 2020 and 2021, when Amazon sellers were selling their businesses like crazy during that big bubble of Amazon aggregators. I mean, I think the investment paid off, because a lot of clients that came to us and had to do these really complicated, they're selling their business, right? They're exiting. These were people who they're selling their business for 10 million. I knew them when they were barely making 200 grand in
Wow.
gross. So it sort of is our strategy to kind of reinvent certain aspects of legal, make it a little bit easier, get people talking to lawyers, because the other side of it too is the biggest issues that people have a lot of times, in my opinion, it's preventable. So it's the old adage that an ounce of prevention is better than a pound of cure. And people go through their businesses and they make decisions. They never think, hey, if only there was some lawyer I could just bounce this off of and just double check. And they don't do that. And then sometimes it's that failure to do that check that can lead to stress down the line, especially in today's world where compliance is really big, especially on marketplace platforms. So I'm a big, it's not just in my self-interest. I really do think business owners, unfortunately just don't think of legal as a necessity when they're starting out. And it's sort of, I guess they're selling themselves short. Like, it's almost like they just don't think they're going to be good enough for it. I don't know, because in my opinion, if you're building a business that you want to build, it's growable, scalable, all those good things, all those above things, you should probably have a lawyer look at it and have a relationship with a lawyer as you get on that road.
What do you recommend? Like someone starting off, right? Now, LegalZoom, for example, I typically make my own LLCs because I mean, I've just read the website. You could spin it up. It's not something that I even hire LegalZoom for. I mean, my first trademark, I filed it myself. Now, again, I consider myself a bit of like a geek, and I read these things and I check it and I look at the difference between, let's say, an image trademark and the word trademark. And I also went and I filed our brand is called Zulai Kitchen. So I ended up filing Zulai by itself because I know, and again, this is my understanding, and I'm not a lawyer, but from what I read, this is important. If I filed Zulai Kitchen together only, and I never got Zulai by itself, someone could go off and use the word Zulai by itself, pretend to be me, and let's say on Amazon, at least I couldn't take them down because I don't own Zulai by itself. It has to be Zulai Kitchen together. And I did it myself. Now, I don't really recommend that to people, okay? Even though I did it, I was just on a super shoestring budget, and, I filed the trademark myself. But, let's talk about that a bit, in your trademark filing.
Let's do that.
Do you want to go as broad as possible? Do you want to get multiple? When should you do a word trademark versus an image trademark, or maybe get them both?
Yeah, you should definitely get them both. You definitely want the word, right? Like if your word is your brand, how you say it, to me, most instances for most of our clients, the word is going to be the most important part, right? So you definitely want the word to go the logo. But just to take a step back, you're right. Filing a trademark application isn't rocket science. We're not saying we have magic powers that, our typing is better than your typing. And similarly with an LLC, anyone can form an LLC. It's very easy. In Wyoming, you probably know you can do it in about 3 minutes. It's super fast. But there's a couple things that we can do that you can't, which is, okay, what are you doing with the LLC? If it's just sort of an LLC that you don't really care about, you're not really interested in asset protection, you're not really interested in sort of, making sure that you have a sound agreement. If it's just you by yourself, maybe you'll be okay with that. It's really specific to the person. So, if a person has a lot of assets, like for example, let's say client A worked in corporate for 20 years and they have a multi-million-dollar home, maybe, and they have a bunch of retirement savings and they have assets. It's like you want to maybe just be a little bit more careful with how you put your LLC together. You've got assets to protect versus if you're some college kid who just, you're literally putting your business on your credit card. Not that that's a good idea. I can understand where people would want to avoid the legal cost. And we're sensitive to that. And I actually, even with my retail arbitrage clients, my clients who make their money reselling branded products, people who just start out, I don't necessarily tell them just to jump in and start an LLC. I kind of say, why don't you try the system, see if you like selling, see if it's for you before you commit to having this entity that you're responsible for.
That's what I did. I didn't have an LLC well after a year of selling. Then I created it.
I still don't have one for my reselling. I haven't resold in years, but when I was at law school, I used to resell. That's how I paid for school. I was an Amazon seller back in 2003, 4. Yeah, I never set up an LLC. And there's an argument for maybe you don't need to right away, maybe at a certain point. And then there's the question of, do you want an S Corp? And really, the other benefit of working with a lawyer, if you're working with the right kind of lawyers, you're getting that advice. Like, okay, here's, we like to give our steps in incremental sort of little doses. Like, okay, let's do this for now, right? Come back, check in with us in a few months and see where you're at. And then maybe now you're ready for making an S Corp election, right? Which may save you on some taxes if you're making money, right? If you're not making money, maybe we don't want to make
But then also, the tax return will cost you more because it's more complicated when you file a tax return, correct? People often ask me, hey, can I sit down with you one-on-one? Let me pick your brain, get whatever info from you on how to sell on Amazon, how to get started. Well, guess what? You can sit one-on-one with me for more than 3 hours on my mini course, aaroncordovez.com/start. And I will sit down with you one-on-one and give you all the info that I think you need to get started on Amazon. If you're having success on Amazon, you probably have cash to invest, right? The next level after making it big on money is investing. You have to be able to invest to get really wealthy. I've created a fund where you can put your money into Amazon brands, and because e-commerce is growing, Amazon is growing, and you have operators who know what they're doing, your chance of success on your investment is pretty high. I've created this fund because I do not want people to get burned, and where I can put my own money alongside of your money to invest in the best brands that exist right now. Go to aaroncordovez.com/invest if you want to find out more and you're an accredited investor.
Exactly. So that's part of the analysis. Exactly. You have to be 100%. Right. You've got to look at this person and say, like, are you hitting a certain income threshold? And what is that in your state to the point where you might be able to get some benefit out of that, even though you're going to probably spend at least another 1,000 or more, 2,000 having to file this 1120S tax return and the K1 and all this stuff. And then with trademark, I think what we do is I think we have, we use third-party services. We're not out there scrape, but we do use, we have lawyers who are trained in, how the USPTO thinks about marks when they're close. We do searches for trademarks because remember, it's not just about what's on file with the trademark office. A trademark can predate your trademark if it's being used right now on a website, right? You may have no idea that some website somewhere is using your trademark and they didn't register it, but they do have a prior right, and that may be a concern, right? Or
this is a topic that's important because if someone's using the mark, now, again, you're a lawyer, and I'll ask you, right, your opinion here. Let's say this microphone, okay, or this boom stand, right, and they call it the Extendo Arm. I don't know, whatever. They call it the Extendo Arm.
Extendo Arm, I like it.
And they say, hey, get this boom stand. It's the Extendo Arm model. They don't have it written on here. They don't have it at the brand name, but they kind of just gave that name to this arm. They're just like, this is the Extendo Arm. But like, not really branding it specifically. It's not written on it. It's not written as the brand name. It's not prominent, but it's included on the page. And let's say you do an arm and you invented the Extendo Arm name on your own. You didn't look at this one. You didn't know it existed. And you go to file it, right? The USPTO will probably not find this arm, is my guess. I haven't seen them do an extensive research themselves.
They will not. Yeah, they don't typically go outside the search area of what's on the website.
So they won't find it, and they're going to say, good, that's approved over there. What happens if 3 years down the line that gets approved? In the publication period, these guys do not file against you. They don't say, hey, Extendo Arm is mine. They didn't know it was going live. What options are there for both of these parties?
So what you're talking about there is you have a period of time in the trademark office, right, to where your trademark is fresh, it's been filed, nobody opposed it during the publication period, right? And it can be smooth sailing. But if a person finds out, so let's say the Extendo Arm people find out, hey, this guy registered the mark, we were using it first, right? There's a certain period of time where they can come in later on and try to file for cancellation of your trademark, and basically arguing that they have prior use, right?
And how long is that period? Is that a legal period extended somewhere? Is that just some precedent on a case? Or
you have to there's a way to get around it, and there's actually no way to truly make it permanent. There is something called filing to make your trademark permanent, which I should know this. I'm not the trademark guru in my team, but I think it's like 8 years. I can't remember what it is. It's after your first Section 8 filing, so it's after that. But you can file to what's called make it permanent, which makes the barrier harder. But it's over 5 years, right? Like it's got to be a while, right? And that just raises the burden of proof but it doesn't mean it's impossible. It's still theoretically possible if you can show.
I like that though. I want to make my trademark permanent. Is that a service you guys? I mean, I have a trademark person. I can check it out, but like, let me know.
Yeah, if you've had it it just depends on the number of years you've had it. If
8 years
enough, you can
or
file
something
with
like that.
The USPTO, I believe. Yeah, so I remember it's 8 or 10. I wish I had my trademark person on the team who knows all the dates and numbers. I'm totally not the one who does that, but yeah, no, 100%. We can file. I forget what it's called. It's a couple $100 probably, and then you can file and make it permanent. And basically, it's like uncontestable, I think is the term. Yeah, it was 5 years. 5 years, I guess, is the threshold. So yeah, you could theoretically file to make it uncontestable. Sorry for having to look stuff up.
No, you're fine. Looking it up for me shows a smart person, right? It's the opposite of a dumb person. A dumb person believes they're right and doesn't check anything. Smart person is going to check it out. So
the idea that you're getting at, though, is an important principle, though, in the U.S. trademark system, in that we are a system of first use. This is very different than Europe, though. Right, so in Europe, it's in a lot of European countries, like it's first to register,
and China
so
as
first
well.
to the courthouse.
China as well.
Right, exactly. So if you're first to the trademark office, you can technically take over that name before by being the first to file. But in America, we are first use. So that means that somebody, that's why it's important to do a search outside of the trademark office, because you want to know that. We've found brands, they've been sub-brands of, major companies. We're like, do you want to get into a pissing match with Procter and Gamble over this name? Because you could, right? And the problem we're dealing with is people don't want to wait until their trademarks get registered to start their business, right? Like
Sure.
Amazon has created this sort of concept of brand registry, which is not really brand registry because you can't enforce the mark on Amazon, but you can start putting up the content. And so we can do that. We file the trademark, we give you the little serial number, and you're off to the races. But what happens is, if in a year the trademark office denies your trademark and we don't have a case to
Then, yeah, you have no
to
protection.
challenge that, it's usually you have no protection.
So,
you lose your brand registry.
okay, but now let's go back to this Extendo Arm. So, as the brand who filed it
Yeah.
and it got approved, right?
Mm-hmm.
You could file for the uncontested or uncontestable or whatnot 5 years in, approximately, right? That's what we looked at. That's cool. Now, within that first 5-year period before the uncontested, what can this one who kind of used it first, but they didn't really promote it so much as a brand or as a trademark, meaning they used it, but kind of used it in a low-key kind of way. What options does this brand have?
Well, so you're trying to make an argument. It sounds like so. It's interesting. You're actually walking into one of my crusades for this year that I want to get into, which is people on Amazon. And if I'm just going to introduce this subject because I think it relates really well to what you're talking about. People on Amazon get sort of brainwashed into thinking like, okay, once I have my primary brand registered with the trademark office, my brand registry is working, like you're done with trademarks. And it drives me nuts because we do a lot of exits, right? We help our clients sell their businesses. And one of the things, if you've ever gone through the sale of business, you have to promise certain things about the condition of your business. Like you have to promise that you own the business. You have to promise that you own the assets. You have to promise that of the assets that you own the intellectual property. And not just the intellectual property you registered with the trademark office or the copyright office. You have to promise that you own intellectual property that isn't registered. And so what we often see is exactly like your Extendo Arm situation where people have, let's say they have variations, right? Let's use cereal as a great example, right? There's Kellogg's cereal. That's the brand, right? And so a brand register seller might just stop at Kellogg's and say, well, what about Raisin Bran? What about Rice Krispies? What about Fruit Loops? Like those are all sub brands. They can be brands for variations if there's different flavors of your product or
In a way, that's
or,
like a model, right? That's kind of like in a physical products, that would be like a model, but in this case, it's like a sub brand, Raisin Bran. It's like a mix of flavors or whatnot.
Right. And so you have a branding there that people oftentimes ignore. And then what happens when they go to sell their business, what we've noticed is like now they're all of a sudden they're not certain that they own that branding. And they're like, shoot, this is my, best selling variation of this ASIN and this is my favorite flavor that we make, and now we don't own that. Or they use a slogan. So going back to your Extendo Arm, there you go. You're using sort of a sub-level trademark, right? You've kind of trademarked the Extendo Arm, right? Like this is what you call the thing. And now you found out somebody else before you has also been using that term. I mean, there's not a whole lot of arguments to make in that situation if they're asserting it, right? You could do is you could try to enter an agreement with them. You can enter what's like in a consent decree. So you can enter into like an agreement with them and see if you can sort of.
This is brand A, right? Brand A is the one who actually put Extendo Arm like just somewhere in their title or somewhere in their description. They kind of called it that. They didn't put it on the product.
Yep.
They didn't put it in the brand name. They didn't assert really that they're using it as a trademark, but they have some use. Brand A, they did that in 2010. Brand B, brand C, some big corporate brand, they launched an Extendo Arm. They filed the trademark. They got it approved. Now, brand A, now they didn't use it so explicitly as a thing. They didn't contest it during the publication period. Of course, they could go and make a case and say, hey, it's our trademark, but they haven't used it so much as a trademark. So, like, in a case, right? I mean, as a lawyer,
Well, that would be the
Go ahead.
That would be the argument, right? It would be one of your arguments for cancellation is you'd say that they never used it, right? They would initiate a cancellation proceeding against you, right? This is after. So now your mark is valid. You have a registration number. And they're coming in and they're saying, okay, we think we have prior rights to this trademark, so we're going to file a cancellation proceeding within the U.S. Trademark Office. So they initiate
the brand A, right? Brand A is going to go after the big corporation and say, we want to cancel that trademark because
We were
I had
first.
Extendo Arm on
Right.
my website in 2010.
Right, and maybe the corporation argues that your use was merely ornamental. It was never meant to be branding, right? That would be an
Ornamental.
argument you would try to make, right? They say like ornamental. Ornamental comes up a lot in. I see it a lot with like clothing designs, things like that, where you put, if you put, a picture of a horse, person on top of a whole horse playing polo, like that could be the Ralph Lauren logo. That could be just an ornamental. Right. So there's a differentiation between sort of like the tag that's on the back of your T-shirt, that's sort of the brand, right? Because we've seen it. I've seen people try to trademark Dunder Mifflin from The Office and claim that was their original trademark. I mean, and actually win the trademark and then later. It's just crazy. But really, that's not how you use a trademark when you're making like T-shirts and things like that. Because that stuff that's on the front is really deemed to be typically ornamental in nature.
No,
right?
but people do it all
Not
the time. They
brand
just
itself.
trademark a phrase, so then you can shut down people on Amazon, right? That's kind of like a use that people use.
Right, but you have to have some origin rights to it, right? And the problem is a lot of people are filing bogus things with the trademark office, claiming it's like their phrase, But like phrases like "Let's get ready to rumble," like you can file those trademarks. In fact, like that's another thing I encourage people to do. Like if you use slogans, right? If you have catchy phrases, file for the trademark. Find out if you own them. Right, it's going to make your life so much easier when you want to sell your business one day to know that you can say, "Yeah, I own that. I own that. I created it. It was a cool little saying, and we got it trademarked."
Yeah, and I mean, Let's Get Ready to Rumble. Of course, you didn't create the very first Let's Get Ready to Rumble, but maybe you're the first person who put that on a shirt or something, right? Like, is that what you're like?
Right, or used it in or you used it in commerce. Remember, a trademark is about designation of origin. It's really what a trademark is designed to do. It's designed to tell you where it's from. Right, that's really the goal of trademark. Right, it's to prevent. Right, if you have two identical looking widgets, right, the trademarks basically tell you which one comes from which. That's the idea.
Right.
That's what the whole trademarking is really about versus patent versus copyright.
Yeah, I always look at trademark in a way as like the brand, right? And if you go back to the brand, it's from the cow, right? The cow, you want to know who raised this cow, who fed the cow, what kind of grass was it eating, what conditions were it in, and they get the hot brand and they brand it, right? And for me, that brand is what the trademark is, right? That's typically what makes me think of the trademark is who is the person who raised the cow. Now, of course, it goes and veers off to other things. But.
Exactly. And that's the goal of the system. The system is designed to, when we talk about what infringement is, we're really talking about this concept of confusion where it's unclear, right? If I look at this brand, the reason the trademark office might deny you the rights to a certain branding is because somebody else is claiming it. And so what the trademark office is really saying is, if we were to let you use that brand on your product, that would create confusion, right? People would misidentify the source. They would think it's from them, but it's really from you. That's really what it's all about in a nutshell.
Mm-hmm. Yeah, and people do try to do that, right? Like, you could try to have a phone,
of course,
and you put an Apple on it, and you're trying to sell it as Apple, and you want to charge this money, and it's obviously not Apple, right? Like that's obviously like a very blatant one. So the Extendo Arm, like if you were representing in a case, would you want to represent the company that filed, right? And they got it approved, and they're saying, look, Extendo Arm was merely ornamental or something else, or would you, let's say, prefer to represent the person who's saying, hey, I'm going to try to invalidate this trademark of Extendo Arm? Like, what side do you think has a little more legality?
I mean, I think the side, so it depends on the use, but, I would obviously probably prefer to be on the side of the company that can show and document, hey, I sold this product. It said Extendo Arm, right? When they pulled up the arm, it said Extendo Arm in tiny print.
On the product.
It said Extendo Arm on the product or in our instruction manual, right?
But physically, not like on a website. Would be harder.
Even if it's on a website. I mean, use in commerce is really, it's just being sold, right? So it may not have to be highlighted it doesn't necessarily have to be like highlighted on a website as like, this is our trademarked Extendo Arm. It can be just sort of a subtle subsidiary feature, right? The Extendo Arm, TM.
But you see, like I see, you add Extendo Arm TM, right? You have a website on e-commerce, right? And it's like there could be 3,000 words or something on the whole page. This thing is blah, it's shiny, it'll take you from sad to hero, and there's so many descriptions in the page. And you could kind of say any of those words, hey, we used it. But like, just you using a word to describe a product, I don't know if that would kind of tell you like you're using it. And I'm trying to be like a real case hero.
Right, but that's why we have an exception to the trademark, right? Like we don't allow descriptive words to be trademarked, right? So,
Well, I mean, that's funny, right? Because Extendo Arm is kind of descriptive, but it's also branding.
it is. So I'm kind of letting that go for this, but yeah, the Extendo Arm does sound a little descriptive. It also sounds like a little bit of like a punny, right? Like
I know,
Extendo
but you
Arm,
see,
like
but it's also
Extendomatic.
not exactly descriptive because it's also an O instead of like extending arm.
Right.
So
and
it
it's
has
like
a little,
arm.
it's a
It's not
little
really
bit
an arm.
descriptive.
It's really just an extension of a pole. So I would argue it's not descriptive. But that's what prevents words from being sort of like general words from being, implicated, right? Is that we have, protections against descriptive trademarks. Like if I make blue neckties and I start a company called the Blue Necktie Company, that's going to be a problem, right? Because I'm just literally
100%.
describing what I'm selling,
Yeah.
right?
Yeah.
So. No, I mean trademarks. Usually, it's the words. The safer trademarks are usually words that have nothing to do with the
Correct.
product,
Yeah.
right?
Yeah.
Like, stay away from the punny, stay away from the, just stick with, odd words, and you tend to have a better chance. But it's interesting.
Tiffany's necklace. I mean, Tiffany means something, but it doesn't actually describe a product, right?
But those trademarks achieve something else that most Amazon sellers and e-commerce sellers don't achieve, which is fame, right? Like the standard for fame, and I don't know it off the top of my head, but when you become a famous trademark, it's a whole different ballgame,
In
right?
terms
Like
of
you're
what?
just
Legality
your protection level.
or protection level.
Yeah. Like you just have a whole other level of protection. Like there's a reason why you don't have a lot of other Apple products out there, or Tiffany, you know what I mean? Like even Tiffany's even trademarked their colors too.
Like you could make a Tiffany's camera, you think that
Right.
wouldn't get approved.
Right. Or like, if I wanted to be the Amazon lawyer, like I saw a case about that. Somebody tried to trademark that, I think. And the trademark office is like, no, you're trading off of the good name of Amazon and their
No,
famous.
listen, I agree. No.
So,
I know the Amazon lawyer, and they went after me. Hold on. I have to talk about this case. The Amazon lawyers sent us a thing. First of all, they're called the Amazon lawyers, which is crazy because Amazon's in their name. They use the orange, and I think it's potentially confusing to a lot of people. They think, hey, these guys are approved by Amazon or vetted, but Amazon hasn't gone after them, and I'm not going to go after them for that reason.
I can't comment on that. But I mean, I definitely have read their trademark I read the trademark application years ago in the denial, and it was just sort of an example of, how Amazon was famous and classic case of like, you can't piggyback off of that fame, right? Like you could just get a, but
Good, but hold on. I want to continue this. So hold on. We got a letter, okay?
okay.
And it said, hey, you have this item, and I actually have the item here, but it's in the background. But it's a utensil rest, okay? And it is a design. Now, this product is actually patented. And let me give you the history about this because, I'm going to talk about this just because I haven't talked about it that in depth. The product is patented, but it is patented in 2017 or so, and the first use was in 2015. All right. Now, the USPTO approved this patent, okay? But I have the evidence that it was used a year and a half or 2 years before it was even filed for the patent, which means that's an invalid patent.
Okay.
Now, we got a lawyer from the Amazon sellers guys that said, hey, you can't do this. You need to stop selling. And I said, no, I don't need to stop selling because it's an invalid patent. Now, the problem, and I think this occurs a lot with Amazon, is not an arbitrator. They're not there to kind of talk about this. So when they get pressured and they said, hey, you have this item that is violating our patent, they actually went and shut down our listing, right? And we went and did the appeal, and we told Amazon, listen, this is an invalid patent, XYZ, here's all the proof. And Amazon would not reinstate us, even though it's very clearly an invalid patent. Later on, we had to go to legal and actually threaten to go after damages and invalidate their patent. And then when that got through to them, after all the legal fees, they said, okay, we'll put everything up, and they got our things back up, right? And that was okay, but I would have taken them to court happily because I know this is an invalid patent, and this is a very high revenue, successful product for us, right? So I'm just this scenario is something that Maybe you could break it down a bit.
I had a case I had a case just like that 2 years ago. We had two of our clients that we had this guy who was playing patent troll. When you invent something, you sort of have like a 1 year grace period before you file, but you have a year to file, right? And that's what we call it, the grace period, right? So once you commercially show your product that you intend to patent, if you don't file that patent within a year, you could lose the opportunity to file a patent forever, right? It's gone, right? So you have a window to file a patent. So what we look for when we get patent cases, one of the first thing I tell people to do, I said, this is the poor man's patent search. This is what you can do to get started, right? Use Wayback Machine. Go on YouTube. Look for old videos. Find me that product, not that branded product, but that product, right? That exact thing on a YouTube video from a year before the patent application was filed. If you can find that stuff, right, and we can show, right, because you really can't patent what's already invented. That's sort of the fundamental point of patent, right? We can't patent what's already been, right? I can't take a touchscreen cell phone and say I invented it today and file a patent on it, right? There's a bit of a problem, right? We have prior art. So what we did was we actually were able to find find the exact same product in an IKEA catalog from Sweden in 2016. So it was many years before the patent was filed. And that was probably the best $10 I think we ever spent on eBay, I swear. We filed and we sued them. And we sued them and that's what we did. And I can't get too much into details, but the product's back online. So.
And when you sue, are you suing for damages of being down? Is that something you can get? Someone takes you down like a patent troll. Are they responsible for damages of your lost revenue, lost earnings, potentially lost rankings?
Interesting point. So an interesting question. So the question you're asking is like, okay, so if a person has a patent and they assert it against me and I lose tons of revenue and sales and income because of it, and my product loses value because it can't be sold and all the ranking fell apart, can I sue them for damages? It's sort of a yes and no question answer. So traditionally, no. Traditionally, the right to assert your patent is considered fairly broad. But what was interesting about our case is we got the court to actually say yes, and here's why. Once we showed, according to the court, the defendant in this case, as we were the one suing, once we showed them that their patent was likely invalid or not applicable because we were able to show prior art from that IKEA catalog that I mentioned, they were on notice that they had a patent problem. And so what the court actually did was they said it was like I don't think there's been many cases like this. I'm really proud of the decision. But what they said was because they didn't take down the patent at that time and they kept pressing it, right, with Amazon, that they wouldn't retract, they wouldn't do this, that opened them up to claims under the Florida Deceptive Practices Act, which is state law claims, which are typically not going to be found in a federal issue such as a patent. So in a way, yeah, it depends on how you address it, but but if you can catch them in that situation where you're like, hey, here's a boatload of evidence showing you that your patent is definitely not valid, right? Or at least as it asserts against me, right? As you assert against me, you're going to have a problem. That can open them up to some of those state law claims and some of those other claims for lost profits and unfair competition, things like that.
Because the truth is, it's come similar to patent infringement, right? At the defendant side, like if you are infringing or potentially infringing, but if you're told you're infringing, from the moment you get that notice, right? That moment and in the past, you're only responsible potentially for damages one time. But from the moment you've been told and forward, you'd be responsible for damages times 3. Meaning, now that, because it's a knowing infringement, there's unknowing infringement and then knowing infringement, right? So how does that work?
So that, generally speaking, that can happen. So it's interesting, depending on the types of patents, and I'm not the patent guru, but there are different types of patents. Like some patents, you have to mark the patent. Like you actually have to put the patent, you have to say that the product is patented in order for damages to accrue.
Oh, okay. Like the one that the original
method,
one.
Yeah, like if it's like a method and apparatus or something. I'm not the expert, so
Okay.
like somebody who's a patent lawyer watching this is going to cringe if I talk too much. But I'm just thinking through cases I've been through. Like there are certain patents where I know like you have to mark them, but you're right. Like there is an intentionality element. So once you knowingly infringe, right, the damages becomes higher, right? You're at a higher risk, right? It becomes more than just a reasonable royalty. It becomes something more. So you do run that risk if you continue to sell. But I mean, the problem with patents is that I think people, they're expensive. They're expensive to obtain, and they're expensive to enforce, and they're expensive to defend. And then with Amazon, as you know, they do have a patent arbitration process, but it's not gonna.
Only for utility patents, correct? Only for utility.
Actually, no, they do design patents now. They do offer it. Apparently, I haven't checked recently, but as of months ago, they were doing design patents too. Actually,
And so is that for the person contest, like the person saying there's an infringement, or for the defendant? Like, who can initiate the arbitration?
The person who has the patent, only the patent holder can initiate. So the patent holder initiates, right? So you have to send a chart of claims to Amazon and convince them that this is the way to go. If Amazon agrees, then they'll offer the arbitration to the potential, the accused infringer, right? And then the infringer has to decide if they want to pony up I think it's like $4,000. So each side ponies up $4,000, I believe.
Mm-hmm. Yeah, the neutral.
Then,
from my understanding, it was called the neutral patent evaluation system or something.
Correct. Right. And so each party ponies up, and the losing party doesn't get their money back. So the losing party pays. But the way it works is the initiating party is the patent holder, and then only if the patent holder once the patent holder initiates, then if the person who's accused of infringement decides to accept, then they have to pony up their $4,000. Then the patent holder has to pony up their $4,000. Then it gets assigned to the arbitrator, which is typically just like a lawyer. Like the last time I did it was it was a patent lawyer in Chicago. Just no, you're just a patent lawyer, right? Not just a patent lawyer, but just
What doesn't make a lot of sense to me, and maybe you have a contact either at Amazon or someone who can do this. One, I have never seen it for design, and when I recently checked it out, it was only available for utility. So if you have otherwise, please send that, and I'll put it in the show notes and other people to check it out.
Yeah.
But what is a little strange to me is if someone can be taken down without the arbitration. So like if it was for design patents, like our design patent was taken down, what happens is supposed to be kind of this arbitration. But if they can take you down without arbitration, I think the person who's taken down can say, hey, I want to initiate this arbitration instead of just being taken down cold turkey. And I believe I was not able to do that only because it was design patent and not utility patent. That's my understanding. But I do believe if you're taken down utility patent without any arbitration and you're taken down as the take it downee, you can say, hey, I want an arbitration instead. And then you could get that, I think.
There are not a lot of cases where we see just cold takedowns. It happens from time to time. If it's blatant.
For utility or for
size
design.
of the company. For utility especially, right?
Okay,
design actually more often. Before design was in the patent evaluation program, and again, maybe it's not anymore, but I remember.
Yeah, because I know the design, they get taken down like that.
Sometimes they do, and sometimes they don't. Sometimes they get taken down like that. Sometimes the Amazon doesn't want to deal with it. It's weird. They go through moods. Like sometimes there's a mood where you can just get them taken down right away, and then the mood changes. Like it's like people are abusing design patents.
And so let's say this arbitration. How do you engage it? You're a patent owner. Do you know the process of how to do this?
Yeah, so you file you basically we send to legal, we send them a claims chart, make a pretty strong case that this is infringement, and then legal usually comes back and offers the arbitration, and then
so to get this evaluation, you got to go legal, you're legal to Amazon legal, and then they offer it.
You have to go through legal channels at Amazon. You're not going to get it through. It's not just a brand registry button push.
Okay.
It's you have to be a known patent lawyer. It's not easy. But it can be done. But the number one reason it's done, I just want to say, is like most people do it because they expect the other side to walk away. You have to understand the arbitration is very limited. So you can't reference prior art, which means you can't go and show, like, you couldn't use the IKEA catalog that I had, for example. You couldn't make that argument. What you can make, the only argument you can make that's sort of like prior art is you can say, well, the patent was filed in 2020, and I'm a seller on this product since 2015.
Right.
Do you see the problem there?
Yeah.
So that Amazon will accept as a defense. Like you could say, if I've been selling this, in fact, if you can show that, you might actually get Amazon to drop. Again, we might be able to get Amazon to just drop the patent altogether. If you can show them that you've been selling the product, right? Like here, look, the reviews are, assuming they're not hijacked reviews, the reviews go all the way back to 2015. This patent was filed in 2020. You're going to have a pretty good case that you're in the right, right? And that's going to be good. But let's say you go through the arbitration. So the patent holder initiates, tells Amazon, hey, here's the chart of claims. We think we have a good case for this. Amazon says, great. Amazon tells the other side, hey, you have 30 days to accept this patent challenge. Basically we're throwing down the gauntlet. You have 30 days to accept. If you don't accept, we're going to take your product down. At which point the other side has decided they want to accept. And to accept, they have to pony up $4,000. But they don't just have to pony up $4,000. They also have to pay for a defense,
Yep.
right? And their only arguments that they can make are non-infringement, meaning they don't infringe on that patent,
Yep.
right? Not that there's prior art, again, except in the case where you can show that you were the seller of
Right.
that prior, right? If you are the actual seller, then you can show it. But really, it's just showing non-infringement, and you kind of
You
it's
probably are
expensive.
infringing.
You know, it's like a mini court hearing. You probably are. You might be. But you're going to spend 10, 20, 30 grand. Like, it's expensive. Like, I mean, patent lawyers aren't cheap.
Now, could you just make your own defense? I guess, like, if you were like, hey, this product looks totally different or whatever, and you just make your own thing, is that even, like, it's probably accepted? I'm sure as a lawyer you're not going to recommend it, but, like, in theory you could?
You know, utility patents, it's really about claims. It's really about dissecting claims, right? People have to understand the heart of a patent are in the claims.
Yeah, there's, like, so many claims. In fact, that's actually something I want to talk about. Utility patent, it has 13 claims. If the product that you have infringes on 3 of those 13 claims, is that infringing the patent or no?
Yes. Any one of those claims can get you done.
Oh, so you can't infringe on any of the claims.
Any of the claims, right? And a lot of times the claims will have overlap. Like, it'll say, like, the same as claim 1, but instead of a rounded, it'll be jagged or something. You know, it'll always have those little distinctions, right? And claim 3 will be, you know, claim 1, but instead of a, you know, jagged, it'll be diamond shaped or something. You know, like, there's a reason I'm not a patent lawyer, by the way. I get involved in patent litigation, but I don't make judgment on patents. I don't pass judgment on patents. You actually have to have you have to be an engineering person actually to do that.
Oh, wow.
We're not actually allowed to believe it or not.
You're not allowed to say whether or not it's infringing.
We're not allowed to really render an opinion on whether something is infringing in the utility patent world, because it's patent law is sort of, that element of patent law is sort of reserved for people with an engineering background. There's a whole separate patent bar.
Oh, really?
That, you can even be a patent. Yeah, you can even be a patent agent, which is not a lawyer but trained in patent, and offer advice on, you know, filing a patent, defending a patent, you know, things like that. So
literally if the utility patent happens, so as you're saying, as a lawyer, you can't even tell somebody unless you're an engineer or patent specialist, hey, we don't believe this is infringing or not, essentially.
Right. So, like, patent lawyers tend to have their own sort of, tend to come from engineering backgrounds, and then they can say, so I can litigate it. I mean, if somebody else is making the call, it's just like, I can litigate it. Or if I can show that the product was pre-existing, like, that's fine. I just can't, I can't write claims. Yeah, but I can't write claims. I can't analyze claims. Like, I mean, I can, but it's like, I can't do it and build a client for it. You know what I mean? Like, I mean, I can look at it and formulate an opinion based on experience, but I can't build a client for it, right?
Okay.
I have to use one of my patent people. One of my patent lawyers has to do it for me. I can't make that opinion.
Okay.
So
and so back to this amount of claims. So really, what the Patent and Trademark Office, what they are saying is, each one of those claims are valid in and of themselves on a patent, and they're saying that they've analyzed it, and all of those are new. Each of those claims are something that has not been done before.
correct. Something is right. Right, because you have to disclose, right, when you apply for a patent, you have to disclose what's called prior art, right? So if it has been done before and you know about it, you're supposed to tell, or something that's kind of close to it, then you're supposed to disclose it and then distinguish it, right, with the trademark office and say, yeah, well, that's sort of like, you know, patent A teaches that when you mix this product with this chemical with that chemical, this reaction, but our patent is different because we only mix a small amount of this mineral with that chemical. You know, like, I'm just totally making up nonsense right now. Yeah. So
Interesting.
you try to make those little distinctions where you can.
And what about this? What about this? In terms of a product, let's say it was this stand. And again, this is just a curiosity for me. If somebody patented this grip, this particular way of clipping this thing here, and this maybe, I don't know, by volume you can say it represents, I don't know, 10% of the product or something, or by value 10%. And you got into a case where this was patented, this whole product was selling for $100, and they're going after damages because this person was in fact infringing. What are the damages for it being just a part of the product, and how does that get decided, as opposed to, like, I could say I'm the Extendo Arm original guy, and I say, hey, this thing, this patent, it's not even 5% of the reason people buy. So okay, I'll give you money, but I'm going to give you 5% of the sales because like that's not why people bought this. Or how does that? How would that case go?
So a case like that, they would say, obviously, you would try to settle, and maybe that's an argument for settlement. But really, what they say is, well, look, you sold it. You sold it you sold, X thousand units with that clip, which is infringing on our claim 3. And that's how we got you. You're otherwise you're clean, but your clip runs afoul of claim 3, and you sold X thousand units of those. You owe us a royalty, right? That's how that conversation is going to go. Now, I will say in practice, most patent cases we run into, there are not a lot of, this is not encouraging people to go out and infringe on patents. I'm not, but we don't see a lot of demands for payment lately. People just want you to stop, right? With Amazon sellers, there's probably not a lot of money. Because like I said, patent litigation is very expensive. So,
Correct.
Suing an Amazon seller for selling 10,000 units of a patent for royalty, it's not going to amount to
royalties
much,
are what, somewhere between
right?
like 2 to 5%, something like that, maybe 6.
Yeah, exactly. Like an inventor's royalty is typically not going to run very much. So it's like, what do you
what do you see? Like,
right,
in real cases, how much does that royalty go for if it ever happens that you've seen? Like, what would be a royalty?
No, like 2 to 5, like you said, 2 to 5% is probably on the higher side of inventors' royalties that we see. From the few that I've seen, it's not very. I mean, 10% would seem unreasonably high.
What about this? If it's like this little piece, right? I don't know. Again, let's just say it was a bigger claim. It was $10,000. I don't know, $10,000 in sales. Well, 3% is what, like $300? Is that the case? Well, it's like
$300, right? So,
but like, you're like, well, this clip is not even $300 because this clip is only 5% of it. But they would probably that's the settlement point, as you said.
Yeah, but they could say. And they could say, like, we lost profits. They could try to sue they could try, potentially suing for profits too. I mean, they could say, but
you took our sales.
At the end of the day, we're not just seeing a ton of litigation because the volume of any one Amazon seller just isn't there to make it probably worth the juice isn't worth the squeeze, as they often say. And it's just common in litigation. This is something that I deal with my clients in all cases, right? Like when we negotiate contracts, especially for like smaller things, it's like, I have to be mindful of my cost, my time, because I'm like, it's a contract, it's an understanding. But in reality, if it's a $20,000 contract, you're not going to sue.
What does that mean, a contract? The contract between who and who? What does this contract mean?
Just any contract that you enter into as a business owner, right? Like maybe it's your 3PL, right? Maybe your 3PL did something that cost you 10 grand, right? And you're like, look, my contract says that they were supposed to do this. What I always tell people is like, oftentimes as a small business owner, the juice ain't worth the squeeze, right? Like it's a negative value claim, right? We could spend, $20,000, $30,000, $50,000 in court fees trying to litigate your $10,000 case. So we oftentimes explain to people, like, most of what you do in business as a small business owner, you kind of,
this is good faith.
The contracts are useful outlines, but you have to be in good. Yeah, exactly. Like you just hope for good faith on both sides, and that's going to work out because. If I just think it's part of my job as a lawyer to explain to people, like, just don't think that this piece of paper is going to end your problems. Like, if this doesn't work out,
you're going to have to sue for $100,000 plus or whatever, $50,000 minimum if it's a super cheap court case, I guess.
So, like, if I told you that you had to spend, $30,000 to try to recover $10,000 and you could lose it, I mean, is that a good deal? Is that worth doing? No, I don't know. I mean, we don't make our money taking our clients to court. I'll tell you that. It's just not our firm because we just know who our clients are for the most part. Most of our clients are smaller businesses, right? They're 10 million or under. Some are bigger, but I mean, even though they're bigger, they still, people don't get to be, $20, $30 million businesses just throwing money around. So, you really have to piss somebody off. Usually make them want to go to court.
I have seen some cases, I mean, from a large company that does over 100 million, for example, and they won in court
for sure.
A dumb thing, and they get damages, they get this. And so again, like those, of course, are possible, but as a vast minority.
It's a rounding error, right? Like when I was at Microsoft, like our legal fees weren't even, I remember what our budget was for outside legal would probably be like couple $1,000,000. Nobody cared. I mean, that was like a rounding error. Nobody cared. Yeah. Nobody cared.
Yeah, exactly. So, a couple of things that we're kind of running out of time a bit, but what about filing for trademarks in these other countries? I'm specifically interested right now. You said the UK. If you file for a trademark in the US, does that give you, like from this, there's like some sort of union or treaty or something from these countries, does that give you protection in Europe?
No. You can file for protection. There is something called the Madrid Protocol, which sort of streamlines the ability to claim protection in those countries. But
what if nobody's using it and someone tries to file it 5 years after you? in the UK.
If somebody tries to file it 5 years after you, again, I don't know the UK, but like I know Europe. Europe is a first to file country, so it's really who files first. But what the
And you don't
treaties do
get
allow
first
you
to
to do,
file.
the
You don't
Madrid
get
Protocol.
anything just because you had the brand in the US or anything like that. Nothing.
No, no, nothing. Even if you're using it in Europe, you have to file, right? Again, I don't know the UK off the top of my head, but again, what we typically do is we use Madrid Protocol applications. So there is a treaty involving which allows you to streamline the filing of international trademarks that we can use and makes it fast and cheap. Um, a lot of people like to file in China right now. There's this sort of belief that if you don't file in China, your competitor or some other factory could file on,
They
and then they
do.
could block your exports.
Well, they do
I've never.
file it.
Have you seen it actually happen?
Yes.
They
Yes.
do file it, and
Yes.
they threaten to file it. And there's this whole. There's even like this scam where they like as soon as you file a trademark, you're gonna get an email from someone saying that somebody's filed it, and they actually
No,
sometimes they wait for you to respond to see if
so
you'll
we
file.
have people in China who have filed for our stuff,
Yeah,
and one of them
and
was
that's a pain
granted,
in the ass.
and
So
now we're fighting it. And again, they haven't done
yeah,
anything. There's no exports or anything, but they've actually filed it and first to file.
they can file it, and you can challenge it, and there are ways to win it. But what I don't think it'll do, and I've had this conversation with other patent lawyers in space, and you know, I don't think that China's going to let them block your exports, right? Like that's what most people are concerned about. But
But you've never seen, you've
right,
never
so
seen an export blocked from a trademark that got filed by someone else in China.
never seen it. I've heard the stories. It's like I was describing it with someone like my lawyer colleagues as like an urban. It was describing sort of an urban legend
The Loch
that
Ness
it could
monster.
happen, and maybe it could. But there is actually a law that they passed in China that blocks manufacturers from doing it directly. You know, because they're most likely to since they have the relationship with you and know you, right?
They
So,
blocked
from
them
my
from
understanding,
blocking. They banned them from blocking exports.
and from filing the trademarks for their clients. Because
Oh,
I mean, I think it's a real I think it's a real trade problem for China. I don't think China wants. Like, I think that would be a
yeah.
nightmare PR problem for China if suddenly, like, all of us, we were having export issues in China because we couldn't, because somebody filed our trademarks in the middle of our,
Mm,
like, we're running our businesses, and you know what I mean? Like, I just don't think that's an image they want to, I don't think that's a look that they want to pursue.
yeah, what I
So,
agree with that.
I,
Okay, well, that gives me a
like I
little bit
said,
of
I mean,
comfort, a little
it's not
bit.
very expensive to file those marks. People should, you should file in China. Why
Do you
not?
have
Just,
China
it's
representation
not
in
very
your
expensive.
firm to file in China?
We do, we do.
Okay.
We will again. We can do it through international treaties. We can do it. My team knows how to do it, but we do actually have a Chinese law firm that we work with too, and in occasion when we need the help. So
Okay, so and then if someone who does want to file, like for example, okay, I want to file some stuff in the Madrid Protocol. You said that gets you what in Europe? Does that get you in Latin America? Like what does that get you?
yeah, it covers pretty much every country, all the major countries. So
And
you have to file it like per country. I don't know how it's done. I'm not the one who files it, but it's basically a fast, cheaper, and streamlined way to basically get your trademark covered in a whole bunch of countries.
okay, that's awesome. And then so someone wants to work with you at Reselling. How do they contact your firm? And first, talk about both of the firms that you operate, and how would somebody get in
Yeah,
contact with you to use one of your services?
yeah. So the easiest way to to contact me is to email me Paul at ecom.law, ecom.law, and that's our law firm. And our law firm is there to help people launch, grow, exit, do it again, like the flywheel, right? Exit, launch, grow, exit, repeat. Just keep building those businesses and growing them. And then we have another program, which is not a law firm, but it does have like legal benefits. It's called sellerbasics.com, sellerbasics.com. Um, and what that is like it's an e-commerce Amazon account health program. So we've done a couple things. We make it $100 a month, and when you're a member of our program, Seller Basics, if something happens to your ASIN or your account, like a suspension or a warning or 72-hour notice, like we basically just go to work for you and do everything we can within the Amazon ecosystem to get you back online. And that's covered under your $100 a month. So we basically have taken sort of like insurance style mathematics. It's not insurance, but it's like insurance math. The other thing you get when you're a member of Stellar Basics is you get free consultations with lawyers. So you get to make that phone call, that 15-minute phone call that could save your
Wow.
business. Think of it like Geico, right? 15 minutes,
Yeah.
you get that for free. So it's my law firm and a couple other law firms that have agreed, and we'll scale up more law firms as the program grows. But basically, yeah, you can set up a free consultation with me or my team or other team members, depending on the subject matter question you have, whether it's tax, business, IP, Amazon. And then, so you get the account health, you get the lawyer, then you get discounts on services. So I think to file a basic trademark with us, I think it's $7.99, which includes the government fees, which is like $200. So it's like, I think we're charging like I mean, we don't charge a ton, leveraging the fact that we are respected lawyers in the industry, that we can basically run through a variety of processes that other people can't to try to get your products back online or your account back online or help with whatever issue. We've been attacking. A lot of the resellers really like us. We've been making a lot of friends with resellers because we've been pushing back on brand registry abuse, which has been a big thing. People, if you have a brand and there's somebody on your ASIN, don't just run the brand registry and take them down. You have to really understand what your obligations
who they
and
are.
your rights
Yep.
are, because technically people do have a right to resell your authentic products on Amazon, right? There's other ways to go at them if you don't like it, but Amazon's policies are they don't want their brand registry tools being used to take down competing sellers.
No, I feel like we could talk forever. So this is a really good point
We'll
because
schedule another one. I'll
okay,
come
listen,
back
hold on.
anytime.
I have a question because
But I'm hanging. I'm good.
I
no rush.
have product that we were reselling on other platforms, and we stopped reselling, and then the person who sold to us said, "Hey, we'll buy back the inventory, no problem." So I was going to sell it back to them. They ghosted us because it's a lot of inventory, and I said, "Good, I'm going to go to Amazon to resell." Now I know as soon as I go up, they're going to take us down. And for me, if they take us down, I believe that's legally damaging for them because I have a lawful product, I have a real invoice for it, and you can't just do that.
It's been done before. It's been done. There have been cases. Yeah, you can do it. There's a couple claims you can bring liable per se. If they filed a counterfeit claim against you, especially, then you account, especially if your invoices are good. But yeah, there are other ways to go after this without having to go to court. Because obviously, like I said, we don't like going to court.
No.
It's not what our clients, are built for.
So what would I do? Let's say you're going to help me out. And some of their products are on transparency. So the transparency program, you can't list on there no matter what, even though we have the product. Go ahead.
Except, right, unless you can show Amazon. Now, this is easier said than done, but we've done it before. That they're not respecting transparency, because the way transparency is supposed to work is it's supposed to be the stickers are supposed to be applied to all channels, not just Amazon. So does that, because Amazon does not want transparency to be a means of controlling distribution.
Well, that's what they use it for, 100%. I mean, that is what it's used for. I don't know what to say.
Well, no, that's 100% what people think it's for, but you can get similar, just like taking somebody down who if I have a receipt from Walmart showing I bought your product fair and square, right, and you're trying to take me down as a counterfeit, I have an ability to go to Amazon and I can make a case for getting your brand registry rights revoked, your enforcement rights completely taken away.
Wow.
Right? Because that's brand registry abuse. Similarly, if somebody is in transparency and you can show, hey, wait a minute, I bought these products at Ollie's
wholesale
or Walmart.
No, they gave me an invoice and I have it with the SKU. This is the product.
It's their invoice too? It's not from a third party intermediary.
I bought from
their own invoice. Then you can make a case to Amazon and say, look, Amazon, they're not respecting the transparency. Now, sometimes there's a little bit of there's a delay. Like they can say, well, we just turned on transparency last week, so we have some.
No, they've probably been on it for over a year or 2 years. And
Yeah, no, then they can get in a lot of trouble.
So what happens? So how do I do this? So I want to list it. This is actually the thing I want to do. I want to list this product on Amazon. What's the best way to go about it?
You can certainly you can set up another account. Like the rules for multiple accounts on Amazon have changed, right? They'll claim it hasn't changed, but they've been clarified, right? Like as long as you're not selling the same products across multiple accounts. In Amazon's examples, right? Like you might want a separate account for each brand. Maybe you want one account for your reselling. That would be fine. So you could theoretically go through a reseller account and try it that way. Or you can try it on your main account and, one counterfeit, if it's counterfeit without a test buy, you're probably going to be, they'll shut down the ASIN. They're not going to likely shut down your entire account without a test buy.
Likely, but that's even if it's a 0.1% chance, it's fucking scary, right? So I
know. This is why we have our businesses. This is why we're busy, because we know. But as we deal with resellers, I mean, a big chunk of our clients, resellers love us because we were the first ones to stick up for them. We were the first ones to say, hey, we read Amazon's policies and these brands are violating the policy. That doesn't mean brands can't scare you off of reselling other ways. They can send you scary letters, right? They can use law firms that send you scary letters. They can even take you to court. That's all outside of Amazon policy. They can do whatever they want. Mm-hmm. But within Amazon policy, if they use a brand registry tool to take you down and you have an invoice, they can set themselves up for some serious trouble. But it does take work. I mean, it's not an easy thing to get Amazon to accept that, but we do it all the time. We deal with it.
Okay, tell you what happened. I used another account and I submitted. Now, the invoice is to an email, okay, not to an LLC. I own the email. and
Right.
they said, hey, your invoice is not valid because it's not written to you, because the invoice just has our email and not a company name. So what do you do? What do you do
Right.
from there?
We would probably appeal it and show that this email is being used in this account. This account is associated with this LLC. You know, there's ways. You know, I'm not the one who does it, thankfully, because
Okay.
it drives me crazy. I have a very smart team of people who handle this on a day-to-day basis. But you know, that doesn't sound unusual.
And then what about
Typical.
the date range? Like they say it has to be issued the invoice in the last like 90 days or something. But like why? Like what if
It's
it's from
usually a
2 years ago?
year, right? You have to be able to track a year's worth of inventory. That's what they want to say, right? So they want you to be able to track. They want to show that the inventory you have on hand at any given time matches up to a year, and it's usually a year, I believe, is the deadline. Um, if your invoice is over a year, I wouldn't recommend using it. I wouldn't recommend leaning on it. It's hard. It can be done, but it's hard.
But like the truth is, I bought it I bought it. Let's say I don't know 9 months ago, and it's been sitting in my warehouse. It's not like I'm using an old invoice to sell things over and over. It's like
Yeah. No, exactly. And so that invoice, if it's 9 months old, you can probably still use it for
okay,
another 3 months. But you have to deal with Amazon. But yeah, you have to take the risk that somebody might file an IP complaint. But that's where, you know, and this is something we do for free for our members. So this is something that Seller Basics members who pay $100 a month, they can have 5 of these IP claim cases open at a time at no charge.
okay.
So if you're that's why resellers love our program, because we're just all in on, you know, it doesn't mean we don't help brands, but we're not gonna violate Amazon's policy. We're gonna support whatever Amazon's policies say are the right things to do. So um, if people want to send scary letters to you and say don't sell, that's fine. That's their prerogative. They have the right to do that, but they can't use an Amazon tool to take you down.
Right. Yeah, that's really interesting. Okay, so we covered patents quite a bit. We covered the trademarks. Now, just again, I know I said it in the interview, but guys, always do the word mark. The word mark actually protects you. I mean, an image mark is
100%.
I don't know. I would say almost useless. Like if an image has a word in it, wouldn't the word mark cover whatever the image mark covers? If it has a word, if the image mark has a word in it, wouldn't the word
If it
mark
has the
also
word
cover
in it, right? You want to logo mark your. It's this like thing swoosh, right? Like
Yes.
it's designed really to be something else, right?
Yep.
Like I like logo marks. Like I like my supplement sellers to have good logo marks. Like I think supplement sellers should, because supplement sellers oftentimes are prone to like label abuse. Like they'll use these generic like colors of like maybe just like a white label with like an orange stripe, and it'll say vitamin C, and then they'll have the name of their lab or whatever their supplement company at the bottom or something. And then somebody will come in and use the same template, and then the only thing that will be different is the name of the supplement lab. And I've seen the copyright office and you know reject those types of labels as being too generic. So I think supplement
What does that
sellers,
mean?
you know, I think
Rejected? Is
it's
that
good to
meaning
use.
you can't protect? You can't protect just an orange stripe. Is that what you're saying?
Yeah, like you just can't protect it as a copyright. It's not there's not enough artistic integrity. It's not enough to really constitute a logo, so you're not going to get a trademark. It's just kind of a nothing. It's kind of just generic blah, you know, like almost like think like PowerPoint template. Yeah, like PowerPoint template stuff. Like nothing really unique about it, so it's going to be hard to protect. Whereas if you have a logo, instead of thinking of it as a seller, think about it as a customer. Like log into Amazon and search for your product as a customer and try to see what the customer is seeing. I think it's very eye-opening for people who don't realize this. Like you're going to see a lot of products that look like yours next to your product,
Yep.
right? Sold by your competitors, right? So how do you visually distinguish your product, right? So that a competitor can't rip you off. So if you create a logo or a copyrighted art, you know, artistic, something that you can copyright, either way, and you put it on that product in a very conspicuous manner that's very obvious, right? And the person buying your product, you know, they process that logo, they process that design, whatever it is, right? Then when they go to search for your product the next time when it comes to buy again, right? They're not going to get fooled by your competition because they're going to say, oh, it's missing that logo. And if your competition does have that logo, then you can take them down,
Right.
right? Then you have a great case for takedown,
So, quick
right?
question here. So this is a copy thing that we get actually, I would say infringed on, except we didn't file it. So then here we go. So our logo, Zulai Kitchen, we have Zulai written kind of like in a rainbow, right? Then we have like a little like spatula and fork thing, right? A whisk, spatula and whisk. And then we have, you know, kitchen kind of straight. So it's kind of like this rainbow Zulai and then kitchen sort of straight. And we also have the logo. Now, we've had people come in and make like literally like ZXYL kitchen. The ZXLY is the same shape as the Zulai, like literally as a rainbow. And in the bottom have literally kitchen. So now they're not Zulai kitchen. It's not infringing on the word mark, right? It's not even Zulai. but it literally starts with a Z and it has the same rainbow and the same shape. Can I file like that format of like little rainbow with the little thing right there in that way? Is that something that potentially could be, let's say, either trademarked as like kind of the composition, or you don't think that could be?
I think that's a tough one. I think when you get into just sort of the layout of letters, like in that way, I'm looking at your logo right now. Like, but again, with the spatula and the whisk crossing like that, and the established 2015, like that's very.
Yeah, like the logo by itself, I think we should follow that, and we haven't done it, and I'll put it, right? So if someone does that. But like in terms of the text, that wouldn't be put in an image mark necessarily, because it's not really an image, it's just text in a certain
I mean, I don't think you're going to get much out of that. I mean, the USPTO is going to look to the words, not so much right? So if it's Zuli Kitchen or something like that, right?
Yeah,
and it's in that rainbow effect. I see what you're saying. Like then you'd have a case to say it's just confusing, right? There's confusion. I'm not sure. But again, I'm not the world's greatest. I'm a terrible trademark lawyer. You don't want me as a trademark lawyer. That's why I have better trademark lawyers on my team. I think logos have value. I mean, I think if you stamp that on your product, right, and you have that trademarked as a design mark, then you're going to help prevent people who might come across a different milk frother or whisk, whatever it is, and prevent them from, your brand is very prominently displayed like on your product as I'm looking here, right? So,
okay, fine. Hey, that's a shot, because again, it's like the copycat thing, but it's, as you're saying, to the supplement brand, was I the first person to do a little rainbow in a thing? I mean, I don't know. We didn't kind of sort of invent that, but like
right, like an orange, an orange stripe across a white background isn't really
like,
that innovative, right? It just may not be. It just may be just too generic.
Yeah.
So using logos, I think it's great. And like I said, you talk Tiffany's actually trademarked their color. So I mean, it's like they're that hardcore.
That's a crazy thing. So you trademark the color, but I checked in with the trademark guy, and we have colors. So like we'll make like this certain pink, and maybe we call it cotton candy. Or let's say we just called it something totally different. We called it, Terminator black or robotic green or something. I was told you can't trademark colors. I was told. But the name of colors.
I think Tiffany is Tiffany's famous. It's I don't know the ins and outs of that and of how that happened, but I'm presuming Tiffany's blue is world famous, right? Yeah. So they probably get
it's a different.
It's level. Like a different world level. It's a different level when you're there.
Yeah, no.
It's a really hard argument to make. You really have to be famous, like to be at that level. So.
Okay, and then and what about colors? You don't know much about that, like. You have like this, I don't know, I have this ring right here, and I'm going to call this, dark hell, rock star orange. Like, I can't just make that name and trademark the name of the color of this thing. That's what I've been told, but I don't know. Do you know if that's true or not?
Yeah, I don't know. I don't actually know the answer to that question. That's a good question. I'm not the trade. I can bring Bethany on here. She's my diehard trademark resource, who I go to when I ever have these questions. But I would think you could give it a name, right? Like you give it but I think you could just call it that. I mean, I think you could. Just
but it wouldn't be like the color, but it would be like the product. That's my product, and that's the name for it, right? You wouldn't say like I'm trademarking the name. You just say, hey, this is my model. This is the trademark for this model. And then it's protected, basically.
Right, but you're getting the variation protected. Right, you're giving a branding to the variation. Right, which goes back to my original point about I think people are forgetting to do. A lot of bigger Amazon sellers are forgetting to do that. As their catalog gets bigger, they're forgetting. Like they're still leaning on just the one trademark they filed, years and years ago. And it's like your business is much more than that now.
It's true. Okay, awesome. Well, Paul, it's been phenomenal. We definitely went over, which was fantastic. And I think we'll have more conversations for sure, because this is a topic that really protects you. Honestly, without any legal prowess at all, our company would have gone bankrupt already. We've been through legal battles multiple times, and we've been on both ends. We've been on the defending side. We've been on the plaintiff side. And this is an important topic, and I really appreciate you being there, an advocate for sellers. And so, guys, sellarbasics.com and then ecom.law, right? That's the website. Can they go to ecom.law?
Yeah,
perfect. So ecom.law, seller basics. Have those conversations with the lawyers. That is worth something. You've already listened to this podcast, so it's important. check it out because Paul, seems like absolutely the real deal. And who else is doing this? Not many people. And again, I can't recommend some of the competition as literally you've gone after me for a clearly bogus claim, and I fought it off. And I let's just not say any more names. So
No, we love what we do. I love this industry. I started this law firm by accident. Like I said, I was a corporate lawyer working for really big companies, and I just saw this need. I wrote a blog about sales tax. Actually, it's what started my whole practice, and I love it. And we are advocates. We don't just serve our clients; we serve our community. We were the number one cited resource in the antitrust investigation in Amazon's treatment of sellers. We were very vocal. We've taken on court cases to protect Amazon sellers and taxes during price gouging. During the pandemic, we challenged certain things that we thought were too far. Governments were, like during the pandemic, we had clients who were afraid to sell Nintendo Switches on the internet, and it is a bit like the Wild West. People, when you're a small business owner and you're used to opening up a small business, you're usually thinking locally, like you're in your town, you're opening up a tea shop in the middle of town. Like, no, we're opening up a shop in worldwide. And so we've really built our practice to sort of give the kind of guidance that I'm used to giving the Fortune 500, but providing it to the smaller businesses because I think that's what was missing when we started our law practice. That's what we saw was missing, and that's what we set out to do every day.
that's awesome. Appreciate you.